Condition number 4, the court could find it true, grant the motion, and sentence you up to 10 years in the prison and up to a $2,000 fine.
David Allen Hernandez faces Judge Stephanie Boyd after admitting to missing months of probation. The courtroom goes silent as the consequences loom. Prison or rehabilitation?
Court is calling 2024 CR 009659, State versus David Allen Hernandez. Could I have parties announced?
Those are for the state.
Ryan Arnett for Mr. Hernandez.
And are you Mr. Hernandez? And counsel, you ready to proceed on the motion?
Yes, Judge.
All right, Mr. Hernandez, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same David Allen Hernandez who was placed on community supervision in 2024 CR 009659 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams, on November 21st, 2024, for a term of 10 years? Is that you? All right, state.
Violated condition number 4 in Bexar County, Texas, the defendant David Allen Hernandez did then and there fail to report to the supervision officer as directed for the months of May, June, and July 2025 in violation of condition number 4.
Just one moment. I need a box stand. For a motion to revoke. To that, how do you plead? True or not true? I'm sorry?
True.
State will waive the remaining violations.
Any objections to the state's waivers?
No objections.
All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 10 years in the prison and up to a $2,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
Yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to deny state's motion, continue on probation, but alter and amend conditions for state ISF on the track.
And what is occurring with the new number 1s that are in the document?
So the new number 1 we engaging is not active with our office, but this act is being rush filed so that we need to.
All right. So, Mr. Hernandez, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
David Allen Hernandez.
Why didn't you report?
Me and my girl fell on bad times. She got pregnant. I was really dealing with that situation. I was my probation. And we were kind of out. Lost our spot. We were standing in the vehicle. Our vehicle, 2 other kids. And that's really why I just started focusing more on the babies than the report.
All right, and where has that?
She's got an apartment now.
No. I mean, the fact that you were focusing on the children, which I don't know if that's true or not. I'm just listening to what you're saying. So what did that accomplish by not reporting? And so it appears that she's able to function without you, because how long have you been in custody?
3.5 months.
3.5 months. So she's been able to get a place without you, a place for the children without you. And are these your biological children? All right. So I don't understand why you should be continued, because you've pled true to not reporting for the months of May, June, and July of 2025. And we are here almost in December. So there are a lot of months that you didn't report. So what have you done since you've been on probation?
Stayed away from drugs. This is on probation for. I went to that lot of recovery. That was.
Did you complete lifetime recovery successfully? Probation?
Yes, Judge.
What are you recommending?
In our initial conversation, I recommended, what the ADA and defense council has. come to. On the court summary, they wanted to, alter them in for status.
So my problem to both parties, I don't know if he's been clean or sober or not, because he hasn't reported.
Yes, Judge, I understand. And if necessary, he could undergo a new type evaluation. And if substance abuse is what the court deems necessary,
Hernandez claims family struggles kept him from reporting. Judge Boyd doesn't hold back. Will compassion win, or will strict justice prevail?
then we understand that. We just thought ISF cognitive would be more appropriate in this case because we thought it stemmed from maybe not being in the greatest spot in his life, but not understanding how to make the decisions to prevent being in those spots and how to come out of those spots without any sort of harmful thinking to either himself or others.
But that's what lifetime recovery teaches you. When you're in the sober support meetings, that's what they teach you to make better decisions. I don't think he's appropriate for probation. He's been gone. So, yes,
I believe that he would be a good candidate for probation. I think that it's not that he made a mistake, he made a decision and it was a bad decision. And he's now here on this MTR. He understands the gravity of not reporting. It's not as simple as just not reporting and continuing on probation. He understands that he must be reporting as directed by the probation department. He's willing to undergo the ISF cognitive for 90 days inpatient to correct his thinking to continue to be a good candidate for probation. And he is really looking forward to correcting his own behaviors for his future children. As he said, his girlfriend is currently pregnant with twins. Those will be his biological children. And then also the two children that he takes care of that are not his biological children.
how old are you?
21.
So you should know you need to report.
Yes.
And so here's my question. Were you arrested or did you turn yourself in? Where?
Leaving a restaurant, taco restaurant, getting taco.
Probation, do you think he would do well to be continued or no?
I'd say let's give him a chance. And if he doesn't report or if upon the first infraction, we file a motion to revoke.
All right, here's the thing. I'm going to give you two choices. You only have two choices. There isn't a third. Don't ask for a third. I can revoke you. I'll sentence you to 3 years in the prison. You'll get credit for any successful inpatient treatment because legally I'm required to give that. Or I can continue you and you're going to ISF. Which do you prefer?
I'll take the ISF for trying to see my kid for.
Oh, so here's the thing. I don't know what the wait time is for ISF, but you will be in custody and be transferred. All right, the court will deny the motion. Alter and amend conditions to include ISF cognitive. Is that the local one, Ms. Abrams, or no? Okay. Is there anything else he needs? Is there anything else you need from the court to be successful?
Yeah. I need help with that. I really need help.
Help with what?
My mom, thinking pattern. How they said from Kentucky.
And then Judge, just for the record, when he was saying that, I was just talking to him. Whenever I was appointed, it was notified on the appointment letter that he was homeless. He would like to be recommended for any housing services as well to help him with housing going forward.
All right, upon release, resources for housing and employment. And the court previously required parenting classes. You need to make sure you complete those. Do you understand? All right, we can go off the record. Here's the thing. You better make sure that you report. Do you understand? Because being on probation doesn't mean I'm on probation. I won't commit any new offenses, so it's all fine. That only works usually for municipal court with tickets. You understand? All right, good luck to you. You're welcome.
And then Judge, do you know if those parenting classes, can they be completed in ISF or?
You'll have to speak to
Okay.
probation
Right.
because sometimes those classes are transitional there, which
Yeah.
ones they have.
Okay, thank you, Judge.
All right, you're welcome. All right, you're charged with theft of property less than $2,500 with 2 or more convictions as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. Court is calling 2025 CR 004627, State versus Alfonso Lopez. Can I have parties announced for the record?
Trey Maurer for Mr. Lopez.
And are you Mr. Lopez?
Yes, ma'am.
Counsel, have you received all discovery and did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, your understanding, I'm just to wait the enhancement out.
We have no objections.
All right. Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with theft of property less than $2,500 with 2 or more convictions as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's an $800 fine. State is opposed to your applications. They're taking in consideration 2025 PF 42484. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There were not.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, sir. State upper states exhibit 1 and all attached.
No objections.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you requesting a PSI?
We are, Your Honor.
All right. It will be 8 to 12 weeks, or if you would like, it could be shorter. And what will end up happening, I'll just hear any witnesses you all would like to present.
I think we would prefer the shorter one. I would anticipate just having one witness, Your Honor.
All right, Ms. Abrams, this is a waiver of PSI and TAP evaluation.
Okay, good, thanks.
All right. Ms. Ferguson?
I'm sorry, Your Honor, I misunderstood. So that means that you would not do the PSI, it would just, okay, I apologize. I think we, let me kind of take a step back
Sure.
and go for my client real quick.
Okay. What page is Lopez on?
I can look at that.
Thank you.
Up one from the phone?
Yes.
I'm not on page 2, 3, 4, 5.
All right, thank you.
Yes, ma'am.
Oh, I don't know.
Yes. Sure. All right, thank you. All right, yes.
Your Honor, I believe we will waive the PSI and just present the one witness when we come back.
All right, how much time are you requesting, counsel?
As far as when we come back,
It would have to be in December.
maybe that first week of December, Your Honor, or second week of December.
All right, Ms. Ferguson. All right, I'll give you your date. All right, do you prefer the first week or the second week?
The second week, just so I can ensure that I can get my witness down here, Your Honor.
All right, so it can be the 8th, the 9th, or the 11th.
The 9th works for me, Your Honor.
All right, so we'll come back on December 9th. At that time, I'll make a decision on your requests based upon any evidence that's presented to the court, okay?
Yes.
All right, thank you.
Thank you, Your Honor. May I present the rejection to the
Yeah.
case?
There you go.
Judge,
You're welcome.
maybe excused.
Yes.
The courtroom is tense as Judge Stephanie Boyd calls the case of Alfonso Lopez, charged with theft of property under $2,500 with prior convictions. From the outset, Judge Boyd ensures Lopez and his attorney have reviewed all discovery, pleadings, and admonishments. Every right, from jury trial to confronting witnesses, is explained, leaving no room for misunderstanding. Lopez enters a no-contest plea, fully aware of the consequences. Judge Boyd meticulously confirms that Lopez has received fair representation, was not coerced or threatened, and is legally competent. The state outlines its opposition to any community supervision, considering his criminal history. With clarity and authority, Judge Boyd finalizes a 2-year state jail sentence and an $800 fine, showing zero tolerance for repeat offenses. This short but intense hearing exemplifies the power of courtroom procedure, the weight of prior convictions, and Judge Boyd's firm, impartial justice. Lopez leaves with a clear understanding. In her courtroom, the law is applied decisively, and consequences are unavoidable.